Gönenç Gürkaynak. Welcome to Digital Markets Research Hub. It's a great opportunity for us to engage in a conversation. And the formal reason is that you have recently published a book, Innovation Paradox in Merger Control, published by Concurrences. And obviously, the very title paradox refers us back to the very common, very popular, and very accurate term, which reflects many phenomena in competition law and policy. And that was my first question, or at least that was the original plan, until I noticed the dedication in the book, which is very touching, to my father, Professor Mehmet Rustu Hurkaynak, with love, admiration, and gratitude for teaching me to stay hungry for knowledge and towards life through his elastic strings of questions and joyful morning whistle tunes. I think many of us, if not most of us, have in one way or another somebody with whom, to whom we have referred the same or similar deep, sincere, and friendly words of gratitude. So perhaps it's just, however trivial or banal it may sound, I wanted to share this feeling and to say thank you to those, to my father as well, and maybe others will do the same.
I thank you, and this is very kind that you have observed this. Indeed, I am quite privileged, quite happy that I found the chance to dedicate the book to my father, who is a questioning man, a curious man, who is a man that keeps away from stereotypes or presumptions and wants to inquire about things, and has taught this to my brother and to me. So yeah, I really truly appreciate that in an academic context like this, you prefer to open up with this sentimental note, which is very valuable for me. Thank you.
Absolutely. Thank you very much. And I think that's the attitude with which most of us, I imagine, were shaped, have contributed to channeling our curiosity and open-mindedness in many respects. So with this in mind, let us revert to the elasticity, to the paradox and merger control, which is primarily related to the situation in the future, is full of instances where we witness this elasticity of law. So my first question to you, can you please reflect upon this legal elasticity? Is it a bug, a feature, something which we somehow more or less domesticated and know how to treat, or it's kind of open-ended? How do you perceive this instrument, this apparatus in your profession?
So merger control review obviously is the most intricate and difficult aspect of competition law enforcement, in my view at least, because there is a degree of speculation that is inevitable. There are projections and there are analyses relating to the future. Whereas when you're enforcing against a behavioral matter, be it a cartel type matter that requires duality, or unilateral conduct matter of the abuse of a dominant position sort, there is a clearer mandate of finding out whether there is a wrongdoing. Whereas when you're looking in the merger control context, you're always doing a futuristic analysis as to what this concentration is going to mean for that particular market going into the future. And there is both types of errors available for the engaging competition agency. They might be doing too mechanical, too cold an analysis, devoid of spirit, and therefore that may lead to under enforcement. Or they may be too animated and too spirited, and therefore they might be writing up their own stories and engaging in scaremongering, which leads to over enforcement. So a fine balance needs to be found, and that can only be done with consistent and meaningful, balanced burden of proof and standard of proof understanding in the field of merger control, which is what this book is trying to do, particularly in the digital markets sphere, and particularly in innovation-intensive markets where innovation theories of harm are being devised. because if merger control in and of itself is a tad speculative, the most speculative part of merger control must be the innovation theories of harm side of it. It doesn't mean that it is therefore in and of itself dangerous, but it should mean that it requires a particular care in handling that kind of theories of harm, as you might be turning into the very demon that you're trying to protect competition from, and you might be, as the antitrust agency, you might be engaging in over enforcement or under enforcement in markets that are quite sensitive together with their ecosystems.
And as a follow-up question, how did you structure your book then, so that the potential readers and those who are already familiar with this book could somehow visualize the structure and the main topics?
This book imposed itself upon me from an article, so it was going to be an article at the very beginning. My books have typically imposed themselves upon me in that fashion, except for one of them where I decided to write a treatise on Turkish competition law and explain everything about Turkish competition law. But the other books, the prime objective of competition law from a law and economics perspective, or the fundamental tenets of Anglo-American law, or this particular book, these have been ideas that I tried to explore with an article and then failed in doing it in an article because I went too deep into fundamental concepts that are building blocks of what I am trying to say, so much so that there are chapters and chapters. At some point, I realized that this wants to be a book. I think, partly because I was also intimidated by the fact that I was saying something controversial and I wanted to say it, but I needed more ammunition to be able to say what I was saying, which is that there is a paradox. So it came in a more voluminous sense as compared to an article. The structuring of it, therefore, has been one where I first go on a journey of what is innovation anyway, and what historical connotation has there been on the vocabulary or the term innovation, and how did innovation evolve in terms of humans' perception of innovation? How did it become a part of the regulatory environment? And what is the journey in terms of competition law and innovation? So this has been a whole chapter on it. Then I have gone into the law and economics of it and the economic approach to innovation matters in another whole chapter, and integrating all of this in competition law. So one by one, all of the cases that are either paying lip service to or are doing genuine deep dives into the innovation matters in the competition law context. And any case that has anything to do with innovation theories of harm historically have been one by one analyzed by me. Only then I have moved on to what I was trying to say, which is the paradox itself and where the standard of proof should be, and how we should handle innovation theories of harm in the merger control context. So it is two things at the same time, the book. One, if you wanted theoretical information on the concept of innovation and the interface between innovation and competition law, and how industrial organization and economics has handled it so far, and how that has interacted with competition law in general, you have all that information. But then you also have case by case by case, not missing a single case that has anything to do with any of these. There is explanation and analysis on all of these. Then I move on to the standards of proof and the burden of proof issues, where I start articulating what the paradox is and how it should be handled, basically.
And if you look at the evolution of merger control, it's one of the fields where, which is by definition international or multi-jurisdictional, and for the smooth universal functioning of the economy in the globalized world, the more homogeneous the approach, the standards are, the better it is. So I imagine that in the recent past, where the ideas of kind of more or less globalized, homogenized international trade were the main trend, we've experienced significant standardization of approaches and visions. Whereas now it looks a little bit more fragmented. Is it the case? Do we see that with abandoning or questioning more and more the validity, the reliance of law and economics, we somehow open it to other theories, and different jurisdictions start being more frivolous or more proactive in interpreting different societal interests which have an impact on specific merger approval, or they were able to do it even before using the vocabulary of law and economics, and it's just changing of vocabulary, nothing more.
Now, going deeper into law and economics in the matter of competition law means that the issues of competition law need to be handled with the help of sophisticated economic analysis. And if an antitrust agency were to be doing that, obviously that agency would necessarily need to have these types of capabilities. And the danger of over advertising law and economics approach is that some agencies that may lack this type of an understanding or capability may get rid of bright line rules too easily. So what I'm trying to say is typically when you're advocating case-by-case economic analysis, you are assuming already that there is the capability to do the case-by-case economic analysis. And when you're advocating case-by-case economic analysis, you're typically trying to convince antitrust agencies to move away from presumptions and bright line rules and works every time type of principles. And those principles are actually handy, and they do provide legal certainty if there aren't enough capabilities of a case-by-case economic analysis in a given matter, which conversely means that you might be engaging in disservice by advocating that these should be removed if there aren't the required economic analysis capabilities. So one has to be quite balanced, and the same formula that could be proposed for the United States or Canada or the EU or some member states in the EU or some of the emerging market antitrust agencies that do have an economic analysis capability may not actually work for some others. And if they were to follow suit, and if they were to also get rid of the bright line rules under the banner of engaging in law and economics analysis, what would fill the gaps wouldn't be solid economic analysis, it would be speculation. So I think unified understanding of wanting to move ahead with more economic analysis and less bright line rules, less presumptions is not always the way to go, and one has to select the jurisdictions in which this would be more fruitful. Add the innovation issues in it, and you will also find the following. Not all jurisdictions are innovating jurisdictions. A lot of the competition agencies in a lot of the jurisdictions are at best looking at a jurisdiction that is doing copycat innovation, but very few of them can claim to be the antitrust agency of the jurisdiction that is originating the very innovation that is being regulated, which in turn means that a lot of agencies might be a little too entitled to regulate something that isn't even occurring in their own land at that particular given point in time. Of course, it's possible to regulate the effects of something on your own territory, and we do this in competition law, but at the same time, it's very difficult to collect data on it. The innovation behavior, if I were to regulate this way, how is it going to impact the innovation climate in general? Am I disincentivizing or not? These questions cannot be remotely answered. So the global nature of competition law requires very good communication among the sophisticated competition agencies and the emerging ones.
But overall, if you look historically, retrospectively, what is your impression? Do we have more cases investigated? Are they being investigated by more or less the same standards, or we start witnessing more and more diverse jurisdiction-specific factors influencing the decision? Is it getting more or less predictable? Is it getting more technical, or a little bit more relying on broader principles or bright light rules?
The global merger control enforcement, in my view, is getting less predictable. And there are more and more complex, more frequent and more complex grounds on which a transaction can be challenged, especially in terms of the innovation theories of harm. A lot of these cases were very difficult to find as candidates for trouble. When Microsoft was engaging in Activision, it may not have occurred as a slam dunk candidate for issues in multiple jurisdictions because the theories that are devised are innovative theories in and of themselves as well. I could give, obviously, Dow DuPont as an example, or Bayer Monsanto as an example, but those were earlier examples of innovation theories of harm. So it's kind of natural that the parties to those transactions were sucker punched by the antitrust agencies, because innovation theories of harm weren't explored to that extent, especially in those early stages of innovation. So new ground was being broken. But now when I say Microsoft Activision, there's a whole host of innovation theories of harm cases up until that point. And you could assume that some counsel somewhere might have raised the flag and said, you know, this is going to be a very rough ride. And of course, there would have been certain people that said it. But at the same time, I am quite convinced that no one truly appreciated that it would have been a particularly glowing example of an innovation theories of harm case. Even when the reasoned decision of that decision was written, it kind of felt like the reasoned decision is filled with innovation theories of harm kind of language, whereas the articulated worries were more of traditional types of worries up until that point. So what I'm trying to say is predictability is an issue now, which is understandable. There's no fault of the antitrust agencies there, because obviously innovation theories of harm in and of, in their own nature, basically, they serve a particular worry or issue that is difficult to spot, also for the antitrust agencies. And that's why in those cases, these theories get articulated at a very late stage as well. But ultimately, from a deal maker's perspective, from transactional lawyers' perspective, they are more and more finding themselves in a situation where they thought it was going to be a walk in the park, and suddenly people are talking about these innovation theories of harm, and they need to restructure, or they need to come up with commitments, or the transaction is not going to go through. Another issue I think that is relevant to your question is that in innovation theories of harm matters in merger control, especially in digital markets, but in general as well, there are too many affected parties, and the whole ecosystem needs to be kept in mind. And therefore, the data collection process takes time too. And that also leads to the late articulation of the worries and the concerns, or where the true worries lie.
And as we can see, these trends are not only specific for some very unique or some very heterodox jurisdictions, very proactive, but they are also, we see some trends in the mature, established jurisdictions, trendsetters in pretty much all of them in one way, in one form or another. You mentioned ecosystem, and obviously this alludes to the recent book in Ioannis case, where this theory has been used as a sword, essentially, as a pro-enforcement in the pro-enforcement philosophy, implying that not butterfly effect, but much broader implications on competition than the traditional metrics would envisage. Until now, you've been primarily descriptive in explaining, portraying the picture. I imagine that answering this question would probably require some normative identification as well, or maybe not.
Yeah. So booking Itraveli and some other cases are also revealing another interesting factor, which is featured in some of your earlier questions, which is that even neighboring jurisdictions are getting it differently in innovation theories of harm matters. And when you think of the nature of digital markets, and when you think of how it is actually borderless, it is quite surprising that in a given case, the CMA in the UK may be less concerned or more concerned than the Commission in the EU. I'm not saying that they would be always expected to have the same take on matters, but these are adjacent markets, and up until recently, they were forming one singular integrated economic market. So when you're thinking of a digital market at hand, and the theory is that there is going to be some form of peril on innovation, it is quite odd that we're looking quite many cases where the CMA has a different take than the Commission, and one is so concerned and the other is not. And if this was consistent, if one authority was always the more concerned one, then we could have said, okay, one is more conservative, the other is not. But that's not it either. So from case to case, that also changes. Which also goes back to the question of predictability that you have posed. And obviously, then people get less convinced that there is actually objective standards by which these things are judged, and it looks more temperamental than it should be.
And one, of course, can revert this observation to the opposite side, saying, look, if we again retrospectively look at how many mergers in digital markets have been prohibited, or where meaningful remedies have been introduced, we see that either zero or next to zero. So maybe at the very beginning, the very perception of the existence of some universal truth underpinning with mathematical precision and rigor all the transactions and all the clearances or prohibitions was a relative concept. It wasn't absolute, perhaps. So could this maybe explain a more vigilant and more proactive role of even jurisdictions which which have longer pedigree and experience in these cases towards particular mergers related to digital?
It's possible, and I do agree that there cannot be a mathematical precision in how these cases are handled. The levels of the sensitivity of different jurisdictions are different. Also, the market dynamics can be different from time to time, and that's the reason why there are national competition agencies that are looking into the dynamics of their own markets. But I think it is a fair expectation that overall, if you have one global product that is based on a digital platform or premise, then there should be a basic understanding of what the evidences of problem would be, what would amount to a threshold of concern, and how it would be addressed. When these things change from one jurisdiction to the other too severely, and some jurisdictions even hijack this type of worry in favor of asking for other benefits other than competition law, restoration of competition in their own jurisdiction, then it gets a little too handful for the deal makers, for the people organizing a transaction. One might say, so be it. It's their job that they should handle. But if more and more companies were to walk away from these transactions, obviously, then the exit strategies of startups, exit strategies of newer investment going into the markets is hit, and that in turn means that there might be a perverse situation in the merger control side of things.
And what would be your response to people who would propose the following rationale, not attributing it to specific jurisdiction, but to specific people adhering in favor or pleading in favor of the interests of this specific jurisdiction, that innovation is a must for digital market. You cannot succeed in digital, so it's ipso facto present in all your it underpins and explains your success in digital market. The muscles cannot be trained without innovation by definition, and it's quite universal, but my jurisdiction has specific interests, and my position in the global digital supply chain is getting less prominent than it was in other pre-digital periods. So we want to somehow, we are not satisfied maybe with this innovation per se. Maybe we want to see what type of innovation, what would be the implication, how this innovation is being distributed among different players. Is it innovation generated by single largest company, or maybe we will somehow enable the more equal playing field, more players on the market, etc.
An argument that innovation is so essential for certain markets, and it almost is reduced to the single parameter of competition, that all of this talk about losing innovation capacity or losing innovation motivation because of perverse enforcement is but hot air, and that this is just an empty threat because the players don't have the luxury to lose that motivation to innovate, and innovation will prevail anyway, so no need to be soft-handed. I do not agree with this, as I wouldn't agree with an assertion that, if you have 5 families whose upward mobility chances in the society rely on their child's ability to play football and be a great football player, and that's the only shot that they have to elevating their income and living standards as a family. And one of the families says, "Well, that's my only option, so I don't see how motivation is relevant to my child. This is our only option." They will find out that motivation is still a factor, and being in a dire need does not necessarily govern motivation or future planning or the sentimental aspects of things, as it doesn't cover the capacity to do something. So I think it is true that innovation is in the heart of competition now, and an entity that is huffing and puffing, saying this antitrust agency is killing the motivation to innovate, and if you were to engage in this kind of enforcement, then people will be demotivated, might be overselling that line. That's a different discussion. But these worries cannot be altogether discarded, as some of these worries may be valid. And in any case, these should be valid concerns and worries of the antitrust agencies, because it is well possible to engage in such enforcement in innovation theories of harm matters that companies may one by one start feeling that nothing makes sense anymore, which then makes industries fall into a transactional apathy. It may start looking to certain entities like the only way is endogenous growth, and exogenous growth is no longer allowed. some people may say, and that would be a great thing, endogenous growth would mean that they have the resources already, so they're going to go after it endogenously. Yes, but we don't know the counterfactual. A degree of exogenous growth, meaning a degree of full integration, meaning concentrations, meaning mergers and acquisitions and joint ventures, were going to be allowed. And there may have been public welfare in those transactions being completed, and they're not even going to be offered because the entities are going to feel and think that it's just too complicated. They don't know. This is a fertility problem. It's a problem of how fruit bearing and how quickly fruit bearing certain enterprises and certain steps are going to be in given markets, and that kind of enforcement that supposes that a confused set of players is a good thing. So their only option is going to be endogenous growth. I think would be taking away certain opportunities from the marketplace in the form of transactions that are actually bringing about good synergies and quite significant efficiencies.
You mentioned, among other things, that we don't know counterfactual. And again, this argument is being, or this statement is being used by both sides in the discussion. One saying that the scenario without clearance of mergers would be worse. And other parties say that, well, it essentially gives a carte blanche for all mergers because we don't know for the counterfactual. And so my question is, and there are no specific systemic intentions, neither in the parties representing the merchant party and the merchant party themselves, nor in agencies, to look retrospectively and acknowledge their mistakes, I imagine, for agencies to assess some qualitatively and quantitatively the implications of previous merger decisions on the industry, etc. I imagine that the potential incentive can come primarily from competitors. Do we have a developed area where the cleared mergers are being evaluated in terms of their potential implications on the development of the industry, or it's mainly kind of intuition, gut feeling that, look, we have in digital mergers, it's zero. So it's definitely something which somehow very difficult to convince. And then a counter argument again that, well, look, it's not as bad as it could be without potential acquisitions, etc. So is it being somehow empiricized and calculated?
There are some academic studies that are trying to capture exactly what the counterfactual would have been, but I'm going to answer with a no, in the sense that there aren't enough studies of what would have happened had this transaction not been allowed, or had the disallowed transaction been approved. And we do have enough models actually to give proximate solutions, and it would be interesting and instructive for future calibration of tightness of the net, or the merger control study. So long story short, I think it would be fair to say that we are all discussing about the possibility of type 1 error, type 2 error, or termed differently, under enforcement, over enforcement, or termed differently, false positives, false negatives. We're discussing all of these, but a lot of it is not relying on data. Ultimately, it is relying on possibilities of things, or hunches, or explanations and evidences and standards of proof that don't sit well with us, rather than actual counterfactual analysis of the situation. In some files, there are good counterfactual analyses, but these are prepared by economic counsel or economic analysis providers of the applicants. So they sometimes do get discounted a little bit by the antitrust agencies. And the counterfactual analysis is not where it should be at the moment, is the short version of the answer, I think.
We start hearing more and more often about the possibility of using nuclear option of divestiture in some of digital giants.
Yeah.
And this could come from different places, again, from Western mature jurisdictions. We are not talking about some rather distant places. We are talking about EU, UK, and US itself. And this is getting more and more, or less and less surreal. It's getting more and more something which is being considered or mentioned under Chatham House rules, etc.
Yeah.
What are your feelings about this approach to remedying previous mistakes? Or
I think this type of approach is a reflection of the big is bad type of overall approach, and it misunderstands what antitrust is, in my view, and what regulation means in free market economies, and the fact that ultimately competition law is an instrument of free market economies. This type of regulation is a confiscation, and therefore it's not to be taken lightly. I'm not saying it cannot be done, but from Standard Oil to AT&T to the Microsoft One, whenever this type of an approach has been proposed, it has been deeply problematic. And if you start going down that route, there's going to be very little limit as to when you would stop and to what end you would stop, and there's no controlling it whether certain companies will still want to prosper and do the same great job that they have done that has gotten them there, and how much of the current success of certain entities is owed to monopolistic behavior and how much of it is owed to their business ingenuity and their own success in innovation and their own success in taking risks and turning opportunities into their reality. So long story short, I think while there are people voicing these approaches of, just cold cutting down the certain entities on proxy that their sheer size is a problem for competition law, or for the markets rather. I would see these types of broadcasts and people voicing these types of ideas as people who are trying to make a point that they're really hardliners and they're sick and tired of the current dynamics, and they find the tools available to competition law enforcement agencies insufficient, especially at this point in time when the DMA has kicked in and there's an entirely new toolbox available, and there are new terms that we're using in these markets like tipping and self-preferencing, and competition law is showing that it is able to evolve as well and take on a more aggressive role. I would be surprised if the view that competition law should also be a hotbed of structural remedies being imposed on entities very frequently. If that were to prevail, I would be surprised.
Let us move to the DMA. What is your reading behind? What is your interpretation of this all open-ended fairness and contestability goals, which are, in my view, for right reasons, are being open-ended, but that's my view. How would you evaluate the performance of the DMA, let's say, in the 5-year perspective for the European digital markets?
I think this is the European Commission and Europe taking the lead in a field that they believe was under-regulated all over the world. And I also think that the premise here is that competition law needs help from another dimension, as now it is intertwined with some other regulatory issues and other requirements of fairness and proper conduct. And it cannot all be enforced with the pure tools of competition law. So there's a new data set and the new legislation as a requirement. For better or for worse, it has been done. And now we are going to see which other jurisdictions are going to follow suit and do the same thing or versions of the same thing. It's an important turning point in the life of competition law evolution, because now is it competition law giving birth to this, or is this rather a peer, a sibling to competition law? That's what we will have to invent and discover as we go along. And regardless of what the answer is, the coordination between different agencies and enforcement preferences and policy preferences will need to be handled very carefully.
But what is the difference, apart from conceptual and purely juristic background and implications, between perceiving the DMA as a kind of extension of traditional ex post toolbox versus considering it, again, formalistically speaking, as market integration tool 114 of the treaty? What would be the implications in terms of, let's say, not legitimacy, but legitimacy from the for competition mindset, so to say?
So there will be quite a bit of investigations, my view, under the DMA that would not stick with the traditional line of precedence that we had. The same will go for the US as well. So, you know, there will be, for example, more of essential facilities like approaches without calling it essential facilities. And you won't have to go through the hoops of Oscar Bronner type of approaches, or from a European perspective, the same Volvo v. Vangs and Ladbrokes and Microsofts. It's not going to be the same type of issue for, I'm talking about tying data to data, or tying in general. So I think, long story short, this will change the line of precedence available as far as markets are relating to data. And there will be a different approach to competition law sensitivities, or they might not even look like pure competition law sensitivities anymore. Still, from a practice perspective, it's highly likely that the DMA specialists will come out of competition law specialists, less from the data protection specialists or fields of other regulatory subsets. But it is possible that in 10 years' time, we might be looking at competition law specialists that only do DMA stuff and nothing else. And that DMA-related competition law work might look like a whole separate animal as compared to the rest of the competition law line of precedence, and the certain arguments that work there might not work at all in the other side, or might not even be introduced, because it seems that this is going to be designed as a whole separate toolbox, and other agencies perceive it that way too.
And this leads to the question, would, if this separation or maturing of the DMA into an autonomous regulatory system vis-a-vis the traditional competition law, would it mean somehow, would it underpin the argument that, well, if you have an intention to be more proactive in digital markets, at least choose the road of the DMA, and this would allow us to keep ex post competition law more refined, more economics oriented, or vice versa, the development, the rapid evolution in proactive enforcement and rapid changes in digital markets, if DMA succeeds, would somehow indicate that, look, we cannot, it would be almost schizophrenic to be very proactive in doing pretty much the same thing, but differently in one area of law, and remain very obedient to either human rights center or economic center broad defense, let's say, practices in ex post 102.
I think this is going to take an impact on the rest of the enforcement as well. Once an agency becomes more liberal once an agency has more tools to deal with issues of competition law or its own concerns, it would be contagious to the other fields. So DMA is going to feel like such a luxury to the antitrust agencies that have a DMA-like tool, that their conduct may not go back to the exact boundaries of the boxes that they were using under the traditional legislation that they had. And most of the agencies that are writing up their DMA legislation and proposing it to their legislative organ are trying to already remedy certain issues that they're seeing in practice. So they're building in more presumptions. There's less of due process in there. Under the name of efficiency, they're switching the burden of proof very quickly and early in the processes. And these types of behaviors, once they're ratified as still A-OK from a fundamental rights perspective, may give ideas to the same agencies in the other fields that are not directly related to digital markets.
We started our conversation, Gönenç, with referring to our parents, and I wanted to move into the end, maybe to ask you a kind of personal maybe question. You
Yes.
manage a large law firm. You
Yes.
teach, you write, you participate in different discussions continuously, academic and policy making, stakeholder discussions, professional discussions, and beyond. I imagine you're also active in other fields. So how do you manage? Do you learn? Is it a special kind of technique to delegate it to others? How to build your team? How do you wake up thinking, okay, another 25 or 125 different tasks, another day with this kind of challenge, or you are kind of almost with meditative nirvana, peacefulness and happiness, manage your next day full of joy and pleasure and curiosity and optimism?
So thank you. I love doing what I do, but that does not mean that I am nowhere near nirvana like peaceful state. So I am an intense kind of a person. Intense meaning that I micromanage. I believe in micromanaging too. So people keep on, speaking a big game on delegation. I typically talk about the beauty of micromanaging. It doesn't mean that you undermine people that you're working with. I think that's the mistake other people are making. It means that you have a good team that you really trust, but they allow you to infiltrate into the file, give certain directions to it or discuss something and get out. So you can keep your hands on very many things at the same time, and there is the commitment to the work that is being done. When I go to a doctor and someone's going to handle my operation, or when I have a case that is really dear to my heart, and I'm talking to the person that is featured to me as the person that should be doing it, I don't really want her to delegate and that person to also delegate. This doesn't mean that delegating is a betrayal, but it does mean that there is a fine distinction between delegating and basically just becoming a marketing face of an operation and constantly shoveling all incoming work to people that the client hasn't even wanted or seen at the first place of approach to the law firm. So what I am trying to do is I am trying to make clients aware of my team. I try to feature my team as much as possible. When we write an article, there's always the name of whoever has written it. We don't do the, your name will be in a footnote somewhere type of a thing, but we always feature the people who has put in the time and energy, the senior people also. But what's different with our law firm is that even people at a partner level would allow me to take a look at what's going on and handle things and interact directly with the client. And, we would be flying side by side for a moment, and then I would be retiring to another file, and I would be leaving them alone. And this loop would happen very frequently, which is quite time consuming and difficult also for me, but it keeps me sharp and it keeps the law firm at its best abilities as well, to the extent my contribution to the file is also desired by the client. Now that takes time. The academic side of things, my position at UCL takes time. Then there's other works, as you have counted. So time management becomes an issue. I'm not going to say I'm great at it, but I do have good help on that as well. I have good help from my assistants. I have very good help from the team that works with me, that understands that, you know, I need help in these things. So they try to handle my calendar as much as possible. And then I must say, I take good care of myself in the sense that I'm a disciplined kind of guy. Um, I do use a long chunk of a given day as a business day, and I focus quite well for extended periods of time. So it works more or less. But I must say, I am feeling that sometimes I'm holding on to certain tasks for more than I should. So where there is a mistake in delegation, sometimes happens on the admin side, for example, where from a law firm administrative perspective, I should graduate from something, and you know that should be done by another partner at our law firm. Those things I have been late to diagnose. Now I'm trying to get better at those. So not on the merits of the client work, but on the admin side, I'm just, I think, a man of habits, and I have been doing these things for such a long time that despite the growth and the size of the law firm, I've kept myself in the admin side of these things as well. And very honestly, I should say that I started realizing that I am resenting doing some of these now. And then I ask myself, well, no one is forcing you, and there's an army of, you know, director level lawyers who could take care of these admin tasks, and you both prefer to do it yourself, and you're kind of acting like, oh, this is beneath me. Well, then, you know, why wouldn't you get help? So this is something I'm learning late. I should have learned this bit far before, I think.
Excellent. And maybe based on this, what would be your recommendation to students, law school graduates who want to start their professional career in competition law?
So for people that are in developed markets with good records of transparency, I would recommend that they go into law firms where they matter, where people want to build them and to teach them, and there is a plan about them. So they don't only ask what's going to be my salary this year, but they ask about what's the development plan for me. For students that are going to go into emerging markets, especially markets that may have a bad score in transparency and corruption is an issue in these markets, the first question to ask is, are you doing this on the merits? And, you know, also to talk to the other juniors in these law firms and to understand if they will be expected to get dirty, if they're going to be expected to serve goals and engage in acts that their grandparents wouldn't want them to be in. And that's not only happening in the interviews, that can also happen through peer-to-peer and their own you know, class in those law firms. They may get information, and they should find a clean act and get into that. Then the advice converges, I think, regardless of whether it's an emerging market or a developed market, whether there's a corruption problem in that market or not, in the conduct of legal services. Once they're in a good home that is clean and is with a goal of teaching them, they should just focus on learning and understanding the vocabulary and the mannerisms and the way to interact with clients and the philosophy of it, and also the content. For a few years, there should be, in my view, no questioning of how hard the work is and what you know it looks like once you get in a director position, this, that. I think the only focus should be, am I learning? Am I amazed at, in 6 months' time, how much progress I have made? And does it feel like I am a work under progress? Is there construction around me? If the answer is yes, I think for a good 2-3 years, there should be no questioning of it. More and more in the junior classes, I'm seeing that kind of impatience. So the desire to get results without, you know, planting the seeds, basically. That's not going to be a sustainable game plan. After a few years have been passed in that kind of an environment, it's really to understanding, to my understanding, it's really depending on the preference of the relevant person. Do they like to be a part of a pre-existing structure, or do they want something of their own? Are they ready to bleed for something of their own because it's not easy to make it? In developed market, it's very, very difficult to make it. In emerging markets, there may be more opportunities, but then again, for other reasons, it may be more difficult to make it because the local clientele is typically your clientele when you're first forming a law firm, whereas the local clientele might be requesting things that you're not comfortable with, or they're more prone to doing that. Whereas internationals come in with the security of having policies and never resorting to certain means to get results and all that. So long story short, I think there should be 2-3 year plans of advancement and less of questioning of the overall picture and more of focus on, am I learning and am I developing? One critical question to ask is, would I like to be a more academic person, or do I like being in practice? Also, another critical question is, do I feel more comfortable in a large law firm with a corporate structure and a lot of policies and an understanding of how to build a junior person? Or do I feel more comfortable with a smaller organization that may be more fluid and with less of rules, but at least they would have a more face-to-face contact with the more senior people? Because in bigger law firms, obviously, you will be handled more by the mid-levels, and the mid-levels will be handled by the seniors. So if someone likes a more tutorial type of learning, that may happen better in a small law firm. If someone likes the understanding of experience through doing it, that may happen more in a bigger law firm.
Excellent. Gönenç Gürkaynak, thank you very much indeed for this very informative conversation.
My pleasure.